The first matter to come before the court this morning is State of Ohio versus Robert Starr. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve that time, if you let me know if you get started, excuse me, I'm keeping the clock this morning. I'll keep you apprised of the passage of time. We have read the briefs and are ready to proceed when you are.
Thank you, Your Honors. May it please the court. My name is Kenneth Liu on behalf of the appellant, Robert Starr. A single issue here before the court today, as you know, Fourth Amendment search and seizure issue brings us here. I think I could begin by just summarizing the case. It's sort of unusual in that the arresting officer was observing an individual who was not the defendant. And if we can probably simply characterize the appellant's actions, his actions consisted of driving into a Walmart parking lot, circling a parked car, parking near that parked car. The occupant of the parked car walked from the parked car, got in the passenger side of Mr. Starr's vehicle, and shortly thereafter, Mr. Starr drove away. The arresting officer stopped the vehicle at that time, not based on anything Mr. Starr did, other than what I've described, but based on observations made of the individual seated in the car, Mr. I can't think of his name offhand. So I think the trial court focused on the observations of this individual who was seated in the car. And those observations consisted of the following. It was 8 o'clock on a Wednesday night. It was at daylight. It was at the Walmart parking lot, which is on the edge. It's in the city of Lorain, sort of by the Amherst city limits, right off of Route 58 there. And the arresting officer testified that he was observing this area for suspected drug activity. We learned in his testimony that he had been advised, I assume, a roll call that this is an area to keep an eye on, so that he took up a position in the back part of the Walmart lot to observe. And what he observed, as he testified to, was a vehicle parked, not illegally, but away from the doors, and seemed to be by itself. And he observed this vehicle have an individual, single passenger, or single occupant seated behind the wheel. And the officer testified that he observed this vehicle for 10 minutes. While observing it for this 10-minute period, he ran the plate. The plate came back to a known person to the Lorain police. And this person was known as a possible drug user. And when pressed upon that conclusion, the officer testified that this individual was observed at some point in the past leaving a known drug house. So that was the information that the officer had as he observed this vehicle seated in the lot. No one came to or from the vehicle. There were no further movements of the occupant of the vehicle. And at the conclusion of that 10-minute period is when Mr. Starr came in the fashion that I've already mentioned. So the officer concluded, based on all of his observations, that criminal activity was afoot, and he proceeded to stop the vehicle. I submit that, based on the totality of the circumstances and the test to be applied in this type of a case, that the officer did not have the requisite reasonable suspicion that criminal activity was afoot, that the officer acted solely on hunches and attempted to articulate the hunches, and as you can see in the transcript. And I know that the one case that I cited, the 9th District case, identifies 4 particular areas that courts can look at, one being the location. Now, the officer stated that this was a high crime area, and I'm not for a second conceding that that's a high crime area. The officer just stated that it was. And when pressed on that, I asked the officer, have you ever made any drug arrests in that parking lot before? And he said no, he had not. In fact, he'd only observed that parking lot. He tried to attribute the high crime area conclusion to other officers at the Lorain Police Department. So maybe you heard a roll call, that this is a high crime area, go keep an eye on it. but he attempted to characterize it as such. And I submit to you that the Walmart parking lot at 8 o'clock, when it's open for business and daylight hours on a Wednesday, not a weekend, not late at night, not 2 in the morning, it's almost disingenuous to state that that's a high crime area. And as I stated, the officer could not indicate that he ever made any drug arrests in that parking lot before. I don't want to go off the record, but I've been to that Walmart before, and to call that a high crime area really is
Well, is it really critical that this particular officer had to make the arrest, or could he not learn of prior felony arrest or drug arrests in the Walmart parking lot from other police officers?
Oh, I
Or
think
is that
it-
necessarily relevant?
I think it's fair that he can glean information from other sources. I would dispute that. I'm sure trained officers can gather information from various sources, but it was not articulated in this suppression hearing. There were no other witnesses presented by the state to testify that they had some involvement with that particular location and why it was a high drug crime area, or why they reported to be.
Well, the trial court said specifically that he testified that other officers from the Lorain Police Department have made prior felony drug arrests, specifically from the Walmart parking lot involved in this case.
And I don't think that was testified to.
So that finding is incorrect.
I don't recall that Officer Sedovey, who was the only witness to testify at the suppression hearing, testified to that. I may be wrong, but I don't believe he did, and I certainly know that there were no other witnesses to testify to that fact. So if we look at just the location, I would submit that it's not a high crime area. But for the sake of argument, let's say it is. Let's say it is a high crime area, and I've cited a plethora of cases that indicate that your mere presence in a high crime area is not, in and of itself, reasonable suspicion that criminal activity is afoot. And a number of the cases I cited talk about some alleged nefarious activity in a high crime area where people are congregating around the car, or people are walking away from a car, or the officers drive by and there's a group, and then they drive by again and there's a different group, or it's 2 in the morning and someone walked in a high crime area. And a number of these cases I cited in my brief have held that just because a person is in a high crime area does not suspend the Fourth Amendment. And people have, that you can't paint everybody with the same brush.
Isn't there some significance, though, to the fact that Mr. Starr pulls into the parking lot and drives around Mr. Seslowski's Tahoe a couple of times, and I'm sure don't mean like around the parking lot a couple of times. I got the impression it's around his car a couple of times and then parked 2 lanes over.
Yeah, that's
Isn't there something like inherently suspicious about that activity in and of itself? That's not something that you see every day, right?
I don't know that it's suspicious. It's unusual, maybe.
Okay, unusual.
Unusual. Maybe he was looking for a place to pull up. Maybe he was making sure that was the person he was coming to pick up. I don't know. I mean, I grant it may be unusual, but I don't believe that it's suspicious of criminal activity. The mere act of driving around a parked car and then parking, and then that person gets out and goes into your car. But obviously the officer thought it was suspicious. The officer tended to attribute that to indicator of drug activity, or potential drug activity, I think is possible, I think is the word he used in his testimony. So, granted, I'd say it's unusual, but I wouldn't necessarily say it's suspicious of criminal activity. So even as I was mentioning, even if it's a high crime area, that in and of itself is not the end all. Okay, so there's a factor. Then the second point in the 9th District case is the officer's training and experience. And in this case we had, I believe, approximately a 1-year officer who had been on the force less than 2 years, had been through his training, had been through the academy, and he had actually been a road guy about a year, or a little less than a year. So he also had never made any arrests in this lot. He had never arrested Mr. Seslowski before. that was the person in the car. And he would, so I would submit that the officer's training and experience is negligible. So that is a factor I'd ask the court to also take into account. And it's quite different from I think it's the Hammond's case, the case that the state relies on. And in the Hammond case, the officer in that case had made multiple drug arrests, I think 50 or more arrests. And not only in his career, he made numerous arrests and was a seasoned officer, but he had made numerous arrests in that particular area that was in question in the Hammond's case. So the officer's training and experience in this case, in the Starr case, is negligible. The third aspect that the category, I'll call it, is the suspect's conduct and appearance. Now, if we look at Robert Starr's conduct and appearance, Judge Schaefer's pointed out, his conduct consists of driving around 2 times and then parking. His appearance, we know nothing about his appearance. Officer said if he didn't know who it was, didn't see anything, didn't recognize him, ran the plate, there were no wants and warrants. So there's nothing in Mr. Starr's conduct and appearance that I would submit is anything that's indicative of a drug deal possible. So then we look at Mr. Sedevi's conduct and appearance. And what, I'm sorry, Sislowski's, yes, getting the S's confused. Sislowski's conduct and appearance, as I've already mentioned, he was seated in a parked car, lawfully parked, for 10 minutes, seen doing nothing. He could have been shopping, he could have been waiting for someone in the store shopping to come out. I mean, we've all seen that, we've all done that. We've been with a family member and we wait in the car while they go in to make a quick purchase. So we sit, read a book, listen to music, look at our phones. I mean, you can imagine a dozen lawful things to do while you're seated in a parked car at a Walmart that's open for business. So the officer's observing Sislowski sit there for 10 minutes, that's all. He runs the plate, and that's when they identify him. And here's where the suspicions, I'm sure, ramped up. And they ramped up because they recognized Sislowski. And how do they recognize him? Well, he's a known person to Lorain police. And I asked Sedevi, did you ever arrest Sislowski yourself for drug offenses? And he said no. So why is he known to Lorain police? Well, he's been seen leaving drug houses, or known drug houses. And I asked him, well, was he ever arrested leaving a known drug house and charged with possessing drugs? No. They're making assumptions upon assumptions. And what they're saying is, well, if you're a person that is observed leaving a known drug house, the assumption is you're there to buy drugs. And in a number of the cases I cited, the courts have held that's not sufficient. There's lawful explanations as to why someone could be leaving a house just because there's known drug users there. Doesn't mean that everybody who visits or seen coming and going is there to engage in drug use.
And counsel, you have just over 2 minutes remaining. You may reserve or continue as you choose.
I'll say 1 minute if I could. Surrounding circumstances, I think, is the other, and I think I've kind of touched upon that in my overall talk here today. I would submit that the overall, taking all the totality of circumstances here, that this officer made the stop of this vehicle, the search and seizure, based upon an inarticulate hunch. He acknowledged as much on cross-examination. He characterized it as a suspicion, an impossibility, and I would submit that under the law, under the Fourth Amendment cases that address these sorts of scenarios, that possibilities and suspicions are insufficient to suspend the Fourth Amendment. Thank you.
May it please the court, my name is Natasha Guerreri and I represent the appellee of the state of Ohio in this matter. It appears that Mr. Starr is attempting to review each of the factors that Officer Stivey testified to, that he, in totality, determined that he believed that there was criminal activity afoot before pulling over Mr. Starr's vehicle. However, the test is the totality of the circumstances and reviewing all of those factors together to determine whether or not there is reasonable articulable suspicion to support an investigatory stop. And the state would submit that that is actually present here. We do have the fact that Officer Sadivi was a part of the community impact unit, which at the beginning of his shift, his supervising officer stated that they received numerous complaints from this particular Walmart parking lot with regard to drug activity taking place. He was directed to go to that area and to do drug surveillance. And he stated, based upon his experience and training, that he was looking for particular individuals when he was actually at the Walmart parking lot doing that surveillance. He was looking for individuals who were not conducting business at the Walmart, who were parked away or in the back areas of the parking lots. And it was during that surveillance that he identified a vehicle, which was later to be determined was operated by Greg Soslowski. And Officer Sadivi did say that he had some prior experience with Mr. Soslowski in that he did arrest him previously, however, not for any sort of drug activity, but that he had also witnessed him previously leaving some known drug houses in the city of Lorain. There was also two other officers that were present during the surveillance, one of which was Officer Heathcote. And Officer Heathcote also relayed to Officer Sadivi that he did have some previous experience with regard to Mr. Soslowski involving the illegal drug trade business in the city of Lorain. They were able to observe Mr. Soslowski for 10 minutes. He was not going into or he wasn't observed going into or out of Walmart, nor were there any other individuals in the car that were observed having any sort of activity within the Walmart either. And that was when the Tahoe, after 10 minutes, came in and circled around the vehicle. Mr. Soslowski went into the vehicle and then they started pulling away. And it was based upon the totality of all of those factors that Officer Sadivi, based upon his training and experience and what he observed, determined that he believed that there was some sort of drug transaction occurring within the Tahoe, and that was what led him to actually stop the vehicle. And the state would submit that, and I apologize, that there were, Mr. Officer Sadivi was also aware that actual felony drug arrests did occur within the Walmart parking lot, and he did testify to that factor, and that's on transcript page 7. And the state would submit that the factors set forth, so the facts set forth within this case are in fact similar to the State versus Salmon's case that this court issued. In that case, officers were out doing a sweep for firearms, and the officer was in an unmarked vehicle. He noticed a vehicle parked within a convenience store parking lot where he did have a prior drug arrest, and that area was known for drug activity and drug arrests. The car was sitting there for approximately 10 minutes, as in this case, and the occupant of that vehicle neither went in or out of that particular convenience store. And also there were some individuals that were standing outside of the vehicle that eventually, at least one of them entered the vehicle, and those individuals also did not have any activity going into or out of the store. Based upon those circumstances, this court found that the officer in that case did in fact have reasonable articulable suspicion to effectuate an investigatory stop of that vehicle for drug transactions. And the facts of those cases really are very, very similar to what we have here. Therefore, based upon the facts of those cases, just the totality of the circumstances that we have here, the state would submit that the trial court did in fact correctly determine that the Officer Sadivi here did have reasonable articulable suspicion to conduct that investigatory stop of Mr. Starr's vehicle, and that any evidence that was found as a result of the searches of the persons or the vehicle would be admissible against Mr. Starr. Therefore, the state would request that this honorable court uphold the finding of the trial court and that the matter be remanded back to the court so that the sentence that was issued be imposed. Thank you.
Counsel, in fact, you have 1 minute remaining.
Thank you, Your Honor. You know, I would submit that the Salmon case is distinguishable on a number of points. In Salmon, the officer had extensive drug arrest experience in contrast to what we have here. In Salmon, the location of that was, the officer testified in Salmon, I believe that he had made 50 drug arrests in that exact same parking lot. That's very distinguishable from what we have here. This officer made no arrests in that lot. Maybe another officer had made an arrest in that lot, but certainly nothing like in Salmon. And in addition to Salmon, there were people seen coming and going and actually entering the vehicle in Salmon. We had none of that in this case. Mr. Soslowski, there were no people coming and going or congregating around his car. Very distinguishable from the Salmon facts. In addition, in Salmon, the Salmon was observed making a furtive movement towards the center console as the officer was approaching. And then the officer testified that he appeared to be nervous and excited, and I think those were the words, nervous and excited, and one other adjective. But so based on that, the officer ordered Salmon to roll down the window and then proceeded with the search and seizure.
And counsel, you have reached the end of your allotted time.
Thank you, Your Honor.
Thank you both for your presentations today. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website.